So let's start with cases involving or related to informed consents and informed decisions. Right? Now, a simple case would be someone is sitting in a restaurant, and then you approach the person and then you grab his hand, and then you got a needle, IV needle, and attempted to poke the person or poke the needle into the person's vein. What do you call that? Well, if you just threatened to grab the person and insert the needle, it actually didn't cause that much harm. Maybe grabbing a little bit, but not too tight. In some countries, that would be sort of excusable. They probably think you're crazy, but so that would be assault. It's a threat, right? So a threat of actually inserting the needle. Now, if you grab the patient really roughly, even if you're not inserting the needle, especially if you inserted the needle through the person's arm, that is painful, and it goes through the vein, that's battery, right? So, and usually it goes together. So that's a charge of assault and battery. So that's one thing you might get out of the situation if you don't do decent, well-documented, informed decision-making or informed consent while delivering medical care inside your clinic or inside the hospital. So that would be a charge of assault and battery. You did something that threatened harm, especially physical harm. It could be other harms for some places, but usually physical harm. And the consent was invalid, or there was no consent, or you didn't do it too well, or you didn't do it well, and then the consent is invalid. That's still assault and battery. So that's assault and battery. Usually you're after the legal part to make it look legal, and ethical and moral doesn't hold a lot of water nowadays, unfortunately. Everybody just wants to make sure that they get away with it or it gets done.